Well, good morning. I hope all is going well for you on this Sunday. If you've had a medical appointment lately, they probably asked you if you had an advance directive. Although most of us don't like to talk about the end-of-life issues, it's an important subject, so we'll discuss it this morning, starting right now.
From TV6, this is The Ryan Report. Here's your host, Don Ryan.
Our guest this morning was recently re-elected to serve as the probate judge for Marquette County. She will be starting her second term in January. Judge Cheryl Hill is a veteran of the Marquette County legal scene, and immediately prior to assuming her present role, she was the Chief Assistant Prosecutor for Marquette County. Judge Hill, welcome to the Ryan Report.
Good morning. Thank you, Don. I appreciate it.
Nice to have you with us. Now, I know you have some pretty deep roots in Marquette County, don't you?
I do, yes. I grew up in Marquette County, but so did both of my parents, my grandparents. We go back a couple of generations.
I remember serving with your mom on many committees.
Yes,
yes.
yes.
She was very active. You went to Northern to start
I went to Northern. Well, first I graduated from Marquette Senior High School.
Okay.
And then went to Northern. Actually, so did my grandmother, my mother, my father, and now both my children.
Wow.
So we're really into the community here. But went to Northern and then had to go away for law school.
Right.
Went to Marquette University.
Okay. And you did start out originally in private practice?
I did, yes. I was in private practice for, I want to say, almost 15 years.
Oh, really?
And doing insurance defense litigation, but I always kept my hand in the area of the probate court.
Okay. And did you serve as a civil counsel for a while for the county?
I was the civil counsel for the county of Marquette, first as assistant under Harley Andrews. At that time I was also doing all of the appellate work for the county, but then became the chief civil counsel for the county.
Okay, and then you became an assistant prosecutor, in fact,
Right.
the chief assistant prosecutor.
I was. All the time I was a prosecutor as well. It was kind of all embedded in that office.
Okay.
But at the very end, yep, I worked under Matt Weesey as his chief assistant.
So, you know, being a prosecutor, did you learn some things? Well, obviously you learned many things, but some that particularly helped you to become a judge?
Oh, absolutely. Particularly in my arena, I deal with children, the delinquent children and the abused and neglected children. And as a prosecutor, I was down in that courtroom practicing often. And you know, the prior judge was Judge Anderegg, served over 30 years.
Right.
So I really got to learn at the foot of one of the true founding members of the probate judiciary. So I had a great experience.
Other than Judge Anderegg, and I won't ask you for details, but did you learn any other things from other judges that maybe you decided I'm not going to do it that way?
Oh, not that I'm not going to do, no.
No, okay. So they were all good people.
They were all good people. In fact, I used to practice law with Judge Solka, who's
Okay.
retired.
Right.
Judge Mizuki and I were in the prosecutor's office together. Judge Kangas and I were in college together.
Okay.
Judge Weber's the only new one to me.
Okay. Let's talk a little bit about what the probate court does. People think of it mainly in terms of probate issues, estate issues, but it really has broader responsibilities, doesn't it?
Very much so. I often say probate court is kind of the court that speaks for people who can't speak for themselves. So you are dealing with the trust, the estates. So somebody's passed on. It's my job as judge to make sure that those that have died before us, their wishes get carried out. But I also have the job of speaking for all the children. Children can't speak for themselves in the law, and I do the abuse and neglect docket. So if a child has been abused or neglected by their parents, that's the case I'll handle. I also handle all of the delinquency cases. So any child before they're 17 comes to my court if they've run afoul of the law. I deal with the mental health docket. So anybody who needs treatment for mental health issues, I have that docket. And get a fun assortment of other things. I do all the name changes in the county, and maybe not so much fun, but all the personal protection orders. Really, my day is never boring.
Okay, well that's really interesting. Let's talk a little bit about the probate part of it, because
Sure.
I know it's something that does affect a lot of people. You correct me if I'm wrong, and let's see how I say this.
Okay.
Probably everyone could use a will, but not everyone must have a will. Is that
I think that's
fair?
very accurate,
Okay.
yes. If you don't have a will, there are laws in the state of Michigan that will help take care of how your belongings are distributed after you pass. However, I always advocate for having a will. It is your time, your only way that you're going to be able to make sure your wishes are carried out after you've passed. And you may have a special wish. Maybe you want your mother's dishes to go to your daughter. Maybe you want your grandfather's hunting rifles to be carried on in the family. Unless you write that down in a will, nobody's really going to know for sure. You also might want to be giving money to charity. There are many reasons why you would want to have a will.
And can't avoid some kin arguing about what who
You
gets
hope
what.
so. You hope so. In fact, I often say, if you are planning for your death, that's one of the best gifts that you can give to your family, because after you pass, they're going to be in mourning. There are so many emotions that come up with death. If you've left that game plan, that roadmap for your family to follow, they know the next step, because sometimes that next step's really hard when you're very full of grief. And it also means that you're going to make sure that what you want to have taken care of gets taken care of. I see too many families in court that fight.
Is it necessary that a will be approved by a probate court, or is
No. In fact, when you're drafting a will, you don't even need a lawyer, but I would strongly recommend, I'm a lawyer, so I always recommend going to see a lawyer. They know what they're doing. And it's a roadmap again. You're going to want to identify who you are and who you want to administer your will, the personal representative, and then how you want your property distributed, down to those specific bequests. That would be like the gift of the ring, the gun, or to charity. But a lawyer can also help you look at your entire estate plan, more than just a will. Again, you don't have to have the will approved by a court. We do hold wills for safekeeping, but you could keep your will at home in a strong box or whatever you want, but just make sure if you don't file it with court, you tell somebody where your will is, because you won't be able to after you're gone.
does the will have to be signed by witnesses?
Yes,
They do?
yes, you have to have, and that's another reason to go see a lawyer, but you don't, again, you don't have to. Actually, Google is fantastic.
Okay.
If you Google, Michigan wills and statutes, the laws will come up and you can follow those. It's pretty clear.
Okay. We'll come back and talk about some more of this in just a
Okay.
couple of minutes. Back with more on the Ryan Report after we take this break. Our guest this morning is probate judge Cheryl Hill. Glad to have her with us. Let's talk about the subject we kind of billboarded at the top of
Okay.
the show, and that is kind of end-of-life planning.
Sure.
And truly, it happens to me every time, and I've had a number of doctor's appointments lately, and they all go and ask if I have an advance directive. So
Correct.
tell people what an advance directive is.
Sure. An advance directive is just what it sounds like. It's planning in advance to take care of the directions that you want with regard to your health care. You can also have financial advance directives, but let's talk about health care because you mentioned the doctor. It's a time for you to sit down and think about what kind of care do you want when you're not any longer capable of making your own decisions. It's unfortunate, but many of us will suffer from dementia, or we will suffer from some illness, a stroke, or something that makes us incapable of communicating our own wants and desires. But if you thought about it before you get sick, and you write down and talk to someone about what you want to have happen. Now, it might be that you'd want to be on life support right to the end, making sure they try absolutely everything. Where it might be, I don't want anything. I just want comfort care and that's it. Well, if you haven't done an advance directive, if you haven't written that down, a physician isn't allowed to just make his or her own mind up about what is going to happen with your life.
Okay.
So an advance directive is a document that specifies who you are, what kind of care you are, and then you identify who you want to be your patient advocate. So that's a person that will be making those decisions for you after you can no longer make your decisions.
Now, I know one of these is called a durable power of attorney.
Right.
Just because the word
Sure.
attorney is in there, is this a legal document?
It's a legal document, but you don't have to be a lawyer to be part of a durable power of attorney. Durable means that it goes on. So when we become incapable of making our own decisions, say I have Alzheimer's, at some point I'm not going to be able to make those decisions. And once a doctor determines that I'm not capable, because it's a durable power of attorney, it goes on so that then my patient advocate can make those decisions on my behalf. And it's very important for someone to think about who's going to make those decisions. You want somebody who you're going to be able to sit down and talk to before you become incapacitated, So they really understand what it is you want in medical care. In my example, you want everything done. So you're going to tell your patient advocate, I want to make sure they try everything, every experimental treatment, whatever's available to me. In my example, I didn't want anything, so I want to make sure that my patient advocate will tell the doctors, just comfort care, nothing more. You want to pick a patient advocate who is going to be strong, and I don't mean physically, I mean strong enough to talk to a physician and other family members, because when somebody gets very sick, everybody's emotions get heightened, and that one patient advocate's going to have to make all the decisions. So you wanted somebody who's going to listen, but make the final call and not be afraid to make a final decision. Go ahead.
No, I was just going to say it. So far, two of the key variables seem to be, number one, the best thing is to do it in advance.
Absolutely.
Not when you're kind of already feeling
Right.
the effects. But number two, that selecting that person is really important, because you're not selecting a person to make decisions for you, in a sense that you're selecting a person to make the decisions you want them to make
Exactly.
based on what you've told them.
Yes. And, many people have more than one child. Really think about your children. Sometimes you want to think about who's closest. And I don't mean emotionally, but who lives nearby that might be able to get there quicker? Who is stronger in being able to make a decision? Who maybe has some medical background. Maybe you have a daughter who's a nurse, or you have somebody who has some understanding of medical decisions. And then, because the person has to agree to be your patient advocate, you really want to sit down and talk to them and make sure they understand what's going on. Also, just so you know, you can make a designation and then say something happens and you decide, oh, I don't want to go with that person, or that person becomes ill. These documents can be changed all along. You're
Okay.
not set. You can make it today, but you could change it tomorrow if you needed.
Now, the court doesn't have to be involved, but your doctor obviously has to be.
Yes, and you're going to want to make sure that you keep those documents. You keep a copy, your patient advocate keeps a copy, and I would say give your doctors a copy, all your doctors, because many of us have more than one doctor.
Right.
If you travel, we have a lot of people that travel to different parts, snowbirds. Take your documentation with you so that you have it with you at all times.
Okay.
Now, I think it's one of the best gifts you can give to your family, this planning. If it hasn't occurred, then you can come to court, and then we can work on guardianships or conservatorships. But it's something people need to do now, even if they're young, even if you're 20 years old. Accidents happen, and we don't want to think about that, but you can become incapacitated at any age.
We'll talk about some of those other options in just a couple of
Okay.
minutes. Back with more on the Ryan Report after this 2-minute break. Guest this morning is Marquette County Probate Judge Cheryl Hill, talking about advanced directives. We talked about a durable power of attorney. Short of that, there are things like a do not resuscitate order.
Yes. And again, that's something you can talk about with your physicians. If you're in the hospital, you can talk about it with your lawyer, too. A do not resuscitate order is something that oftentimes with people who are already under a durable power of attorney, their durable power of attorney, their patient advocate will sign this for them. In the example that I use, you wanted everything done for you. You're probably not going to want a do not resuscitate order, but if I have indicated that, I don't do those heroic methods. A do not resuscitate order is something that either I will execute beforehand or my patient advocate will do that.
I notice there's also something called a physician's order for scope of treatment.
Yes, post. That's brand new in the law.
Okay.
It's not even a year old yet. And that is to kind of fit in where we didn't have anything in the law. So if your physician has determined that you're probably not going to live for a year, the order is between you and your physician, so the lawyer doesn't get involved in this one. But you and your physician sit down and talk about this treatment for this last year. And it is an order that goes with all of your medical records. Now maybe you've heard about HIPAA, which makes it a little more difficult for medical records to be shared.
Right.
This post order doesn't, and it is to go with you if you live in a nursing home to your next doctor, and it's much more specific. It really talks about things like intubation, feeding tubes, things that you and your physician would know much more about.
So this would be very specific to you and
Very
probably
specific.
the sickness that you're going through at that time.
Yes, very much so. I spoke at a conference recently, and the director of medicine was there, and he said the hospital here in town is starting to implement this because it's been so new. But he came here from Minnesota and is well aware of this type of an order, so they're getting on board and going to be offering it to their patients very soon. Again, if you have a post order, you want to make sure that you keep a copy with you. In fact, at this conference I was talking to some EMS people, and they love when, if you're still at home, you put these orders right on your refrigerator. Might seem a little silly,
Right.
but if you collapse on the floor and they come to get you, and there's the order, they'll know exactly where to look and to find out what it is that you want to have happen to your own self.
As a probate court, you also deal in guardianships and
Yes.
conservatorships.
That's okay.
Conservatorships.
There you go.
All right. But and these are not just for health reasons.
No, not at all. A guardianship is for anybody who's incapable of taking care of themselves once they're past the age of 18. And a guardianship could be for somebody who has a chronic mental health issue and is not capable of caring for themselves at the time. It could be for someone with a physical issue. The one thing about guardianship is that there will always be a hearing in front of a judge in order to make sure that you qualify to have someone else speak for you. So if we go back a minute when I talked about having advance directives, if you don't have one and then you come down with Alzheimer's or you come down with something that you've had a stroke and you're not capable of taking care of yourself, your family member can come to court and ask that the court appoint a guardian for you. So they would kind of step in the shoes of similar to your patient advocate. But a guardianship proceeding does require full court proceeding. There has to be medical testimony, and you can even have a jury trial if you as the person don't want to have a guardian.
Okay.
And conservatorship, you mentioned that. Guardianship generally we think of as taking care of your person. Your medical care, where you live, that sort of thing. Whereas conservatorship is kind of taking care of your money, your finances, or your estate.
Would a person have to have an attorney then when they appear in probate court to deal with these issues?
The probate court will appoint first what's called a lawyer guardian ad litem. And those are lawyers, and their duty is to go out to see the individual who is being petitioned into court for a guardianship or a conservatorship, to talk to them, to find out what do they want. And if they don't believe they need a guardian, that lawyer guardian ad litem's job is to come back and report that to me, and then I will appoint an attorney. Anybody who doesn't want to have a guardian or a conservator will get a court-appointed attorney, because we're talking about taking away people's rights.
Okay. And that same rules apply to limited guardianship, which I know is a possibility, and
Yes.
the conservatorships.
Right, and limited guardianship just means that limited. If you have a full guardian, you're kind of in charge of everything.
Right.
But perhaps somebody is still pretty good about taking care of where they live and what they do during the day, but really just needs some help with medical decisions. So any probate judge could format that order so just one limited area of their life they're not in charge of.
I wish we had more time, but we're out of time. A very
Okay.
important subject. Thanks for coming in and talking with us
I
this
really
morning.
appreciate it, Don.
Okay.
Thank you.
I'll be back with some other thoughts for you in just a couple of minutes. Well, you know, the Christmas season, the Christmas shopping season is here, and as I was walking through a mall the other day, it was a sad reminder of how things used to be. Yes, it's time for another walk down memory lane with a wistful look at how things have changed. I don't use the word wistful very often, but I think it works nicely today. It was fun to remember the days when there were dozens of stores open for business in that mall, and the corridors were teeming with customers as they walked from store to store. At one time in Marquette, there were 2 malls, and both were thriving places. In some communities, the malls put the downtown districts out of business or forced them to change dramatically. So whatever happened to malls? It seems they're failing all over the country. There are still some that are very successful, especially the super malls in large cities, but that's not true in many other places. One of the problems for many malls is the disappearance of the anchor stores, the bigger stores that at one time would attract a large following. Many of the large chains like Sears, Penney's, Macy's, Yonkers and others are closing many locations, and some of them may be on the verge of going out of business. Then there are other large stores like Menards that have left malls to open in their own standalone locations. Shopping habits are also changing. Many people are staying home and shopping on their computer, buying it online, spending hours walking through the malls, stopping for a coffee or ice cream break, running into friends and neighbors. Just isn't the entertainment it used to be. I guess people today are in too much of a hurry. They're too busy doing other things to waste time with casual shopping. Buying on the internet seems to get bigger every year. Published reports show that on the recent Cyber Monday, American consumers spent $7.9 billion, making it the biggest online shopping day in U.S. history. Getting the best bargain seems to be the biggest factor when it comes to shopping. Perhaps it's always been that way. As I think about it, I'm reminded that malls came and now they're leaving in my lifetime. I can remember when there were no malls. In fact, there were no big box stores as we call them today. While larger cities had their big department stores, areas like Upper Michigan had thriving business districts made up of smaller stores. They were individual shops that specialized in men's clothing or women's clothing, furniture, appliances, hardware, drugstores, and others. It was also a time when people weren't buying on the internet, well, because there was no internet. Of course, they did have the Sears, Montgomery Wards, and J.C. Penney catalogs. And speaking of shopping, I was lamenting a week ago or so that it's possible to go to the large supermarkets and make your purchase with self-checkout and never interact with anyone working in the store. As we get older, it's hard to let go of how things used to be. I guess that's what memories are for. I'll be back in a minute. Well, as we wrap it up for another week, let me remind you once again that our show is also available on the internet at uppermichigansource.com. Today's show will be there tomorrow. Thanks to Judge Cheryl Hill for joining us today and sharing some important information about end-of-life decisions. And thank you for joining us. Look forward to seeing you again next Sunday morning.